This is a $100,000 settlement. Your client just won. Everybody's shaking hands. How much of this does your client actually get to take home? Well, before you say $100,000, it's not. It might not even be half of that. That gap between the number everybody celebrates and the check the client actually deposits is the entire job nobody teaches you in law school. So today, that's what we're going to break down. If you're a law student or a brand new associate, even a paralegal, this is the part of the case that the bar exam never shows you. You learned how to win the money, but nobody showed you what happens to it afterwards.
Exactly. In torts, you learned duty, breach, causation, damages. Beautiful. That's how you win the money. But the second half of the case is the distribution, where that gross settlement gets carved up before a single dollar reaches your client. Here's the way I want you to picture it. A settlement isn't a payday, it's a pie. And there are four hungry people standing around it: the law firm, the medical providers, the health insurers, and last in line is your client. And the order they get paid in is where Washington law gets interesting, because Washington actually flips the usual pecking order in a way that protects the injured person. We'll get there, but let's start with slice one.
Yes, slice one, the attorney. In the standard personal injury case, the contingency fee is usually about a third before a lawsuit is filed and 40% when you're in litigation. And that's just because the work and the risk jump up considerably. So on our $100,000 example, the firm takes about $33,333. Well, your client's pie is already down to $67,000. And here's where new lawyers make their first mistake. They think that the fee comes out and you're basically done, but you're not, because there's a second slice that trips up new associates constantly. Fees and costs, they're not the same thing.
Yes, say that again, because confusing them is how you accidentally shortchange your own client. Fees and costs are not the same thing. The fee is the firm's cut. Costs are the money the firm fronted to build the case. Filing fees, medical records, the expert who charged $4,000 for a deposition, court reporters, and all of those costs get reimbursed off the top, separately from the fee. So the real first question on any settlement isn't what's the fee, it's fees and costs together before the client math even starts.
Yeah. And now that slice, that surprises everybody. Somebody already paid your client's medical bills while the case was pending, whether that be the health insurance or personal injury protection, sometimes Medicare or Medicaid, they pay for those medical bills up front. And then the settlement comes in. Those payers who paid it, they want their money back, and that's what you call subrogation. The right to step into your client's shoes and recover whatever they laid out. So picture it. We've got $67,000 left after the fee, but the health insurer paid $20,000 in medical bills, and now they have a lien. So that 20 could come straight out of your client's share. And this is the Washington part that should make you sit up. They don't always get their $20,000 back, and sometimes not even close.
Right. And here's why. Washington follows the made whole doctrine. And this rule comes from a case that every Washington PI lawyer should know, Mahler v. Szucs. And the rule is your client has to be made whole before the insurer gets to claw back a dime. So if the settlement doesn't fully cover your client's losses, the insurer's recovery gets reduced or wiped out entirely. The injured person goes to the front of the line, right? The insurer goes to the back. And then we stack a second Washington rule on top, because the insurer doesn't even get its full lien minus nothing. Your work costs money, and Washington says the insurer, has to chip in for it.
Yeah, and that's the common fund doctrine. It's the same Mueller case. You, the lawyer, created the fund, that the insurer now reaching into. You did the work, they get the benefit. So Washington makes sure that the insurer pays its proportionate share of the attorney's fees and costs. So in plain terms, the $20,000 example lien gets reduced by roughly the same percentage you charged in attorney's fees. So the insurer doesn't get a free ride on your labor. So two separate Washington doctrines, the made whole and common fund doctrine, both working for your client. And that's the difference between a frustrated client and a grateful one.
Yeah, and a quick Washington specific layer before we run the numbers. PIP, personal injury protection. It's no fault medical coverage on your client's own auto policy. It pays the early bills fast, no matter who caused the wreck. So this is great for the client. But when the settlement lands, the PIP carrier wants to be reimbursed too. And the same rules apply. Made whole first, common fund shares of the fees. So even your own client's insurer can't just grab its money back ahead of the person it's insuring.
So let's actually run the numbers. You got a $100,000 settlement. You take the attorney fee out, which is about $33,000, so long as it's pre-litigation. Then you take out the costs. Let's say that's $4,000. That leaves about $63,000. Now the lien, $20,000 on paper, but the common fund doctrine knocks roughly a third off of it. So the insurer actually collects about $13,000, not the full $20,000, which means your client's take at the end is around $49,000 on a $100,000 settlement.
And here's the part that matters for you as a young lawyer, if you're listening. That 49 could have just as easily been 35 if nobody fought the liens. The negotiation on the back end, reducing those liens, enforcing the made whole doctrine, demanding the common fund reduction, that can put more money in your client's pocket than the headline settlement number ever did. The case doesn't end at settled. That's just where the real lawyering starts.
Yeah, and this might be too much for this particular video, but there's several other cases that you can utilize in your favor to get that lien reduced even further. One of them being Theringer. The other one is Coons v. Group Health. So those two can potentially, as well as many other cases, can help you try to reduce that lien even further, and in many occasions, eliminate the lien entirely. So if you're going into personal injury in Washington, internalize four things. Number one, the gross settlement is a starting line. It's not the finish line. Always think in net to the client. Two, fees and costs, different animals altogether. Track your costs from day one. The receipts are real money. Number three, find every lien early. Health insurance, PIP, Medicare, Medicaid. A lien that you discover just weeks before the disbursement, that's a crisis. But a lien that you've been managing for months, that's just paperwork. And then four, in Washington, the made whole and common fund are your client's best friends. Know Mahler versus Szucs, Theringer, and all the other cases that apply to subrogation well.
The settlement everyone celebrates and the check the client actually deposits are two very different numbers. And the lawyers who understand that gap and fight for it are the ones that the clients refer their whole family to. So if you're a law student or a new associate trying to actually learn this practice, we break down the parts that they skip in law school like we did today. So thank you for listening. Please come back for more tips.